All right. Well, welcome back. Hopefully you guys were able to get some lunch, take a little screen break, or probably work on other things as well. Beatrice and I wanted to talk a little bit and present about some criminal justice best practice. Beatrice has been doing a lot of research in national best practices, has really dived in and just really learned a lot. And so we wanted to kind of share some of the things that we have learned in our research and as well. With our scenario, hopefully you guys are kind of keeping tabs on that. We've now had our officer involvement. An arrest has been made for Derek. He was determined to be the predominant aggressor and was booked into jail on a third-degree felony of aggravated assault, criminal mischief as a Class B misdemeanor, 3 counts of domestic violence in the presence of a child, all Class B misdemeanors, and a jail release agreement has been issued. Izzy is our criminal justice advocate from our police department and has been involved helping getting Meredith connected to resources and reparation application. Our detective, Robbins, has reviewed the case now, and so now we're where it's charges initially have been filed. So our next presentation will be from Trent talking about our prosecutor role, and he'll kind of talk about the process of after those criminal charges are filed from that perspective. But we wanted to touch a little bit on the victim advocacy piece of the criminal justice process. So just to start off, and if you guys have questions, please throw them in the chat, unmute if you'd like, raise your hand. We can also call on you as well. So the overall for criminal justice advocates, best practices is that you should be able to help the victim and the client understand their role in the process. That's one of the key things that is for them to understand where they can be involved, how they can have their voice involved, their perspective brought in, their information shared, and what their role is in the process. You should only explain what you know, and learning about the system makes it easier to explain without using jargon. I know sometimes when we get really kind of going and we've been in the system maybe a long time and we've been to 100 hearings that we start to use a lot of jargon or acronyms with victims. We want to make sure that we are explaining things concisely but clearly and not using, PO or DV or, different things like that are the acronyms. It's really important for criminal justice advocates to know, and all advocates really, to know the role of the prosecutor, the judges, the defense attorney, law enforcement, and victim advocates, and to understand your role in the process. So if you're a community-based advocate, understanding that you are there to assist or help in the recovery of their emotional and physical well-being, as well as getting them connected to community resources. And if you're the criminal justice advocate, it's important to have that you are there to advocate for them throughout the criminal justice process, also getting them connected to resources, but having them be educated and informed of the process. And so when a lot of times, maybe if you're a community-based advocate, I know as a community-based advocate, I thought, I don't need to know a lot about the criminal justice. I'm going to stay in my lane, but it's helpful for you to understand the process as a community-based advocate so that when the victim maybe has questions and they haven't heard from their criminal justice advocate or there's not one assigned, you can know and help them advocate for that. So that's why we want to have both sides really educated on the process. And when talking with a victim about their rights, you want to speak in general terms, like victims of crime in Utah have the right to these things. Having that you say you specifically have this right, it can be delving into legal advice. And so being more general and saying victims of crime have these rights, as a victim of domestic violence, these are the rights victims have, things like that. And then you should always give a written copy of the resources, but also the Bill of Rights. Hopefully that's something that's in your brochures or your packets or things like that to make sure that you're getting that information. Any questions on that? Kind of those first, these are the really just basics, and then we're going to go a little more deeper. I'm going to turn it over to B.
And after they receive their copy of the victim rights, it's really helpful to kind of know who it's really referring to. We do have our Utah Constitution where it identifies upon request, which is a really something important for us as advocates to really remember, so that way we can empower our clients or the victim in the case to make this request, to be informed and to be present and heard at these important hearings once those charges have been filed, and to submit and have information considered at sentencing. So their victim impact statement, having them understand what that is, where they're able to provide that, and what their right is in this, what it means pertaining to their case. And some of our Bill of Rights do actually only pertain to felony cases. So when reading through it, our statute does indicate that certain sections are just for felony cases. So 77-37-3, that is where it just goes through some of the felony victim rights. We picked out a couple important ones where I think it's just the most that we as advocates have that most like empowering piece of it, where we're able to provide to our client. One of them is being informed and assisted through the process. Just like in the previous slide, it's really helpful to understand the criminal justice system, so that way we can actually then tell the victim what the criminal justice system means and what the role is in throughout the system, helping them understand the role of the prosecutor, law enforcement, and even your role as a victim advocate, being clear as to what your level of confidentiality is. If you're working at a system-based advocate, your level of confidentiality. For community-based advocates, you have that incredible confidentiality as well. So then we're having to really make sure that each of us are helping each other as advocates, and also to best serve our clients. And then when it is, I want to just kind of have it underlined again, upon request. They are able to be notified of any resolution that's going to be dealt with a plea deal, but the victim, upon request, can ask the prosecutor to explain this to them. Like Jen mentioned, usually she's having conversations with the victims about what some of these potential plea offers are initially, but if there is a moment where they want to sit down with the prosecutor and really understand why this plea deal is being given, they do have the ability to request that under the Crime Victim Bill of Rights, and to be informed of those threats. So if a defendant's making any of those threats, we want to make sure that they're aware of that, so that way we can do proper safety planning, protective orders, and all that stuff that comes into being a victim's advocate for a victim in criminal justice system. And then the timely notice of proceedings and cancellations, which can be really difficult if to give, because as we know, sometimes court, we're ready for a hearing, and then all of a sudden the defendant decides to not show, or maybe the defendant decides to continue the hearing, or maybe there's all these other hearings taking place in front of that one hearing taking place, and your case is the last one to be called. So there's always so many reasons for something to happen, but it really is just trying to provide that notice as timely as possible and as reasonable as possible. And I don't think that's able to really happen unless we really inform the victim that they are able to provide their contact information. So how we heard from Jen, through how their district attorney's office runs things. Each county is going to be a little bit different. But then also we have our city, our city justice cases will more pertain to misdemeanors. But for those felony cases, how can we really empower them to make that request? And Vicky, if you could go to that next slide. One of the last kind of, I don't know, it would be called, not the subsection, but one of the last indicators in the Crime Victim Bill of Rights is number 7. It says informational rights of victims under this chapter are based upon the victim providing the current name, address, telephone number, and email. So that means it really is kind of on them as a victim of a crime to make sure that they're providing their contact information. If it does change, do they know that? Because us as advocates, we're in touch with them, and sometimes if we lose touch with them and then they finally give us a call with another number, let's empower them to know that, hey, let's get this number to the court, or not to the court, but to like the prosecutor over the case, or their victim advocate unit as well. So that way they are able to really access those informational rights that are provided by our statute. And also, if there is an email address, they're able to provide that to the criminal justice system or agency that's presiding over the case. So that way, if they need to get a hold of the victim as well directly, they are able to. But this is just kind of more questions for you. How can you help your client provide their contact information? Do you know who that point of contact would be? If they do change that information, are they aware that they have to provide that notice? So that way, if we're at the preliminary stage and then all of a sudden numbers change due to safety, are they aware that they need to kind of reach back out and provide that number so that way they can receive that notice when that following hearing might happen? And also really asking them, as just part of those best practices that I was reading through, is asking them how they usually communicate. This was something that really kind of recentered me when I was reading this, because sometimes for me, just naturally, I want to just text them or give them a phone call. Sometimes there's not enough time for a phone call. But those phone calls sometimes for me, when I was at the West Valley prosecutor's office, sometimes I felt like I was on the phone for an hour. But that's because I was explaining to them the domestic violence code, the criminal justice system, their role as a victim, what to expect in the criminal justice system, but then also what the role of the prosecutor is as well, and really where their role is able to come into place, because throughout the court proceedings are almost somewhat silenced by our court system up until that victim impact statement, or even when they're able to speak at detention hearings. So if there's any hearing in regards to the defendant being released from custody, they are able to speak on those matters as well. So we really want to make sure they know that if any number changes, and if they have a preference to being contacted, maybe they want to have emails about this, but maybe emails aren't safe, so we're texting them, or maybe phone calls if that's what they prefer as well too. But I know that as advocates, sometimes we are handling so many cases, and it can be really hard to be able to sit down with a victim for an hour, or even sometimes less, when we have probably, like, I remember my caseload was like 20 to maybe almost like 30 to 40 domestic violence or crime victim cases for a district court case or courtroom. So then I'm having to contact them. They want to make sure they each know. Each case is very different as well, whether it's on the plea offer, whether it's on the other, whether it's just at the scheduling conference, maybe it's reaching that preliminary hearing stage. What does this mean? And for us as advocates, it really is, I think, really valuable for us to understand what each of these hearings are, so that way we can provide that information to the victim, and they can use their victim's discretion as to whether or not they want to participate and be part of that hearing as well. And then also, is there a third party that can be contact, like an emergency contact? Sometimes it really is, just with different types of individuals, they might not have a safe phone to use sometimes, depending on their circumstances. They might not have their own phone number as well, but maybe they have a third party that they're always in contact with, whether it's a parent or family member or friend, where we're able to call and say, hey, I'm just trying to get a hold of so-and-so. So that way we can provide them some important information. And then at that point, hopefully we're able to get a contact with them. It was really nice, that lap form that West Valley had, because they always provided, not always, but for the most part, we would get a relative number. So that way, when we weren't getting a hold of the first person, we're able to contact that third party and hopefully bridge the gap of communication. And then if there is, if you're in the shelter as well, you have that confidentiality. Really explaining if they want to do a release of information. So maybe you as an advocate can contact the system-based advocate and say, hey, I've been meeting with so-and-so, this is their number, this is their contact information. They would like to know about what's going on in court. So that way we can really work together as a team to bridge the gap. I want to go to the next slide. Oh, was this me too? Sorry, let me pull up my notes. There we go. So these Bill of Rights, like I mentioned earlier, some of these are just for felonies. But then in a different statute, I believe is section 38, it'll talk about how class A and B misdemeanors and felonies and those juvenile justice cases have the Bill of Rights, including them as well too. And it kind of looks a little bit different. They don't necessarily have the right to be informed to each important hearing as much, but they do have the opportunity to receive timely notice of proceedings. So if they are being subpoenaed for any reason, it should be at an adequate time, and they still have the right to submit and have information considered at sentencing. And again, I'm just speaking on the ones that we would be able to like tangibly help with as much. But even just that speedy trial and disposition, I think we all know the frustrating piece. I mean, even before the pandemic, we had a backlog of trials. And then post-pandemic, we have still been, I mean, it's 2024 and we're still dealing with a huge backlog of jury trials. So really even explaining them what speedy trial and disposition could mean, but also knowing the limitations that the courthouses have at the time. So again, that way they can use their victim's discretion to be able to decide which hearings are important to them. So that way they have an opportunity to actually attend. And I wanted to really broaden out or spotlight the misdemeanor cases and the justice court cases when it comes to restitution. Restitution, it is the criminal justice system that is gathering that information. So law enforcement, they're responding out on scene, they're seeing what's broken, and they're gathering the proper information. But the victim is also able to file a motion for restitution or to modify an existing order of restitution if they feel like there's something missing. And if the justice court fails to actually order any restitution, or the justice court orders a defendant to pay, but then it's a lot less than what was requested, the victim has an opportunity to request a de novo hearing. So a new hearing with the district court, so that way they can review that restitution claim and then decide whether or not what's going to be ordered. And then also just remembering our crime victims reparation. I'm glad that we had Mac and Jaime today to really go over the new experience of having an online application and how even their services has even broadened out in their scope. So just really empowering our clients to know that there's all these tools in our system that are provided for them to be able to hopefully either be financially whole or just really have their voice heard is so important and so impactful for them to know that at the end of the day, they are doing everything that's in their power, and that even the system empowers them to do to be heard throughout this process. And then talking in regards to those proper notices, like we read earlier, those constitutional rights to be informed for those felony cases, but also the constitutional right to be treated with dignity and respect, and to have a meaningful role in the criminal justice system. What is meaningful, right? Can the role really be meaningful if they don't know why the hearing is being held or what their role is, or really who the parties are and what the pieces mean in the criminal justice system? Because that way they are able to really prepare themselves to either be heard at the hearing or just be able to listen in and not be hopefully re-traumatized as well. Like those arraignments where they're pleading not guilty can be really triggering, when at the end of the day, it's actually really common for a defendant to plead not guilty at an arraignment hearing. So really preparing them for hearing that aspect and letting them know that this is just part of our judicial justice system and how our defendants have all these rights that are really, really important, but also can be really, really frustrating for victims of crime, where they're being affected and they're the ones that have been kind of having to, regain after all of that. So it may not be enough to tell the victim that any hearing could be a plea hearing, because it's true the defendant can technically plead at any time. But a plea hearing is considered one of those important hearings in the criminal justice system. So, and that means the victim has that constitutional right to be present, or at least provide information, submit information to the court to be considered for sentencing. So that victim impact statement, a victim impact statement that has been given the time to really create and write or prepare for has such a huge impact than maybe a victim impact statement where they just found out 2 days ago, or they just found out that morning of, and they're pushing the hearing to the later afternoon so that way they could just have the sentencing all in one day, and really explaining to them their role for that victim impact statement not only empowers them, but it empowers our prosecutors to also uphold those rights for the victim when they are dealing with those plea negotiations, and they are at that stage. Next slide. So if the victim has requested that notice for those important hearings or critical stage hearings, but isn't specifically aware that the hearing is taking place, that could be a violation of the constitutional rights. And I do want to put in, oops, I have the tab right here, copy and paste. The crime victims rights complaint form is now online, and it's going to be held by the Victim Services Commission. They just actually hired, I believe, Katie Fox, if I'm remembering all the names correctly, to be their victim rights coordinator on it. So Utah Office for Victims of Crime, they're no longer housing the crime victims complaints, but it will be now it's just with the Crime Victim Services Commission. So they're going to be handling these incoming complaints now. So just wanted to throw that in the chat as we're talking about victim rights, especially if they're not having the opportunity to do that, and then not informing the victims of a plea and sentencing hearing. That just denies the victim the opportunity to properly prepare for the victim impact statement if they're wishing to be heard at that sentencing, or if they wanted their victim advocate to speak for them at the victim impact statement. I think as advocates, we would appreciate that notice, right, as well, for us to prepare that and prepare them to what we're going to let the judge know. And providing that notice for those release hearings, we want to make sure we're identifying a safety plan. And sometimes that safety plan means, hey, I'm a system-based advocate. Not everything, but most of the things we're chatting about do have to go to the prosecutor. But there is so-and-so at South Valley Services who is a confidential advocate, who you're really able to have a confidential conversation that isn't going to be tied to this criminal case, and really being able to collaborate with both of those counterparts that we have. And then providing that proper notice would be including the information of the victim, of the date, time and place, and the content of the hearing. And I know that those scheduling conferences or pretrial conferences, it's just a conference, right? It's just a hearing to schedule another hearing, is what I always would joke with my victims, but it really is explaining to them that so much could actually happen at those scheduling conferences, and checking in with our prosecutor to see what they might be anticipating. Maybe they're having conversations with the defense attorney prior to, so that way we can hopefully forward that information to our client.
Thanks, teachers. As bringing kind of in that so the constitutional right of respect and dignity, having that respect and trust, and honoring and respecting the victims' voices by empowering and strengthening their decision making, right? So we want to give them that opportunity to have a victim impact statement, or if they don't want to verbally give, if they want to only verbally give it, give them that option. If they want to give a written statement, if they would like a representative to read that for them, really just giving them those choices and empowering them, and giving them that respect and trust. And understand and inform victims of the possible civil and or criminal justice options or responses. Discuss with the victims the dynamics of their victimization and the legal parameters, right? Sometimes with restitution, I know that victims kind of get confused with civil lawsuits. So they want a monetary value for their emotional distress, not something that's civil. So kind of explaining what the role of and what the limitations of the restitution can be, but that there are options for them to pursue something civilly. I think that having cultural humility and kind of specific to cultural is engage with the victims through respectful approaches that honor them as individuals and their needs. We recognize and honor the role of their cultural beliefs and values, and really recognizing that their trauma response may be impacted by their cultural background or beliefs or values. We want to make sure that we're researching and finding out culturally specific resources. What are the resources in your area? Looking at what are if you have a multicultural center, if you have different ones that are specific to our underserved populations, or to maybe taking some time and learning about a culture that you didn't know about before. Do you know the demographics of those you serve? Are you aware of what's maybe like Natalie was saying this morning of West Valley, has a large population of those that speak Spanish. And so they have, made a lot of efforts to make sure they hire a lot of staff that speak Spanish. So being aware of the demographics you're serving and making sure that the resources, the materials that you're providing, and the information you're providing is accessible to all demographics. With immigration resources, making sure you know who signs U visa forms or T visa forms, those certification, the I-918 supplement B forms. If you're not sure if it's your chief that signs them or your prosecutor, learning that process and understanding who can sign those forms to certify the case, essentially. And then how can they start the process? How can you access them, supporting them through it? It's a long process for U visas. And so that one form that law enforcement or prosecution signs just a very small piece of a very long list. And so supporting them in that process and being educated on that. And then you want to build your trust and rapport with the victim to strengthen their self-empowerment. So what are some ways, you can put it in the chat if you want, what are some ways that you guys build trust and rapport with your victim? I know it takes a minute to type it, or you can unmute and say it if you'd like as well. Listening and empathy, yes. Thanks, Jen. Yeah, we could definitely provide some training on that. We can reach out with Holy Cross Ministries and see if they could come and train on the I-918. So that's great, Kristen. Yeah, making it clear that you believe them, right? As the victim advocate in the criminal justice, your goal is you're the one that's there solely for the victim. Everyone else in the criminal justice process has to stay pretty neutral, but you get to be there to believe them. Being upfront and confidential about your confidentiality. Yes, Savannah, being really upfront with that, and allowing the victims to tell their story, making them feel safe so they're more willing to talk. Yes, Lindsay. Check in about something they shared last time. Maybe like you give example, how did your medical appointment go? Tell them they deserve to feel safe and to be supported. I love that, Abby. I think that's so important to them. They realize you were listening, that you do care, and you want to know how they're doing. Awesome. You guys gave amazing comments. Treating them as equal. Yeah, working in a partnership rather than an expert versus client. I love that as well. Thank you, guys. So having that continuity of care, implementing a vertical advocacy or a team advocacy, and I'm going to let Beatrice expand a little bit more on vertical advocacy versus team advocacy.
Yeah, so that vertical advocacy is more so and this is again, if you have the capacity in your agency, if you are that advocate that's able to take them through the entire process. So at West Valley, at one point I was a district court victims advocate. So once they had that initial appearance, I was the one giving them a phone call. I was the one providing the follow-up contact information. I was the one helping them with the victim impact statements, going to court with them, and ensuring if they did want to talk to my prosecutor that I was bridging that gap, or if there was additional information they wanted to provide, helping them speak to our court investigator that we had access to. And also if there was any more handoffs that I needed to do, if it was needing to call South Valley Services with them or contact housing resources for them, really being that one advocate and point of contact. But it's also, I think we all know if you're not the only advocate in the place, it would be nice to have that team advocacy, letting them know. Every time I would end my phone call, I would always say, hey, there's a team of 6 of us. So you have a team of 6 right behind you. So if I'm not available, please know that any of these other advocates are just as informed as I am to be able to assist you in your case. So that way it's not just having that burden on you as one advocate. You're able to have that teamwork and have the space to really work together, not only with your team advocates, but also with your client, and helping them know that they have a whole team behind them and they don't have to depend on just one person as well. And this, I think, really just helps them empower them to know and to have to always feel comfortable accessing these resources as well too.
Yeah. We want to empower them to request that notice. In the Constitution, it's upon request to be informed and educated on the process. So letting them know that they have the right to request that and to participate in the case. Know the resources for victims if the case is filed, or if it's a non-filed case, they still can access resources. And then it's really important to know how to access information on those that are incarcerated. So knowing how to access your local jail roster. VineLink can also look up, you can see where someone is incarcerated. I think making sure you're educating the victim that on Vine that it's not an update on court. It doesn't inform you of court dates or court hearings. It is solely for whether the person is in custody or not, and to also let them know so it doesn't become traumatizing to them when they get a notification at 2 a.m. that they are going to be notified if the defendant is moved from a different unit. So maybe they're moved from medical unit now back to their regular cell, or they're moved from Gunnison prison to the Salt Lake prison. They are going to get those notifications anytime the defendant is moved from a different location than the cell they were assigned. And so letting them know that, and then also letting them know about the Board of Pardons and Parole if the case is that felony level and going to be serving prison time, how to access that, and who's the point of contact. And we'll have a presentation from them later today. And I know Trent is ready, I think, to go, so we'll quickly wrap this up. The collaboration, I loved that someone had said treating them as an equal and as a partnership. Really, that first step is collaborating with the survivor first. Sometimes we get so ready to here's all your resources, and we're just so ready and gung-ho to give them everything and make sure they know they have a lot of resources. But our first step is collaborating with the survivor and asking them what they need, how we can meet them where they're at. So know your system-based advocates, but also know your community-based advocates. Having those individualized safety plans, including resources that are applicable to them, and know your local law enforcement agencies. Being aware of who are the sergeants or lieutenants over the special victims forces, the cases. A lot of especially bigger police departments have detectives specifically assigned to special victims, knowing who the sergeant is over patrol shifts and things like that, and be able to provide that meaningful, warm handoff. Maybe if we have a little time more later today, we can show you guys, but being aware of the different courts website, there's a lot of information on there that is free to access. You don't have to have an exchange login, that you can look up court hearings. And so maybe empowering the victim that they can also search that there. They can find the information if maybe they haven't heard from their advocate or things like that, but letting them know. Beatrice put that link in there. Being aware that criminal justice advocates are usually either under prosecution or law enforcement or Department of Public Safety. If you're not sure on the prosecution, calling the prosecutor's office, getting to know who the legal secretaries are that are handling those notices and letters that are going out. And then post-conviction, Board of Pardons, getting to know who Shanna White is and their team. They have a really amazing team now. And also Laura Flanagan, that's their trauma-informed advocate that's separate from that, who can be really in that role of an advocate instead of a witness coordinator, where Shanna has some limitations because of her role. She has to have that neutrality. And so Laura can step in when Shanna can't. So being aware of those resources as well. So I know that was kind of a quick, really overview, but we wanted just to highlight some best practices in regards to criminal justice advocacy. Is there any questions that you guys have before we turn time over to Trent? Okay, I'll give you guys a second if you did have a question. Sorry, I'm going to stop sharing screen. There we go. Okay.